Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-Immigration. You're probably hearing a lot of buzz about how law firms are starting to use artificial intelligence. And while I recently had the opportunity to talk to the folks at Serenade about their case management system, e-Immigration, they've been making software for immigration attorneys longer than anyone else. And they're doing some pretty cool stuff with AI. They have a suite of tools that they're calling AI Workmates. That sounds like it's got huge time-saving potential. One of their tools even lets you upload a PDF and instantly creates a client profile. There's another tool that can read content on the website and instantly summarize it, which is pretty helpful when referencing historical case rulings or, dare I say, country condition evidence. They've got some other tools too scheduled for release later this year. So if you're trying to wrap your head around how to use AI in your practice, I encourage you to have a chat with the folks at Serenade. Also, check out their blog at serenade.com/blog for their recent articles on AI in legal practices. Or, of course, click on the link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. This stat is going around the social medias, so why not my more historic audio media form? By the time of this recording, well over 100 lawsuits will have been filed against the new Trump administration to try to prevent the Trump administration from doing many of the things that they're trying to do that appear to be in violation of the law. That's over 3 lawsuits a day. Keep it up, America. The lawyers have arrived. Heck, Perkins Coie was hit with nothing other than an executive order from the President of the United States criticizing them and taking away security clearances in response to the firm's legal work. What a badge of honor. And what a small man our president is. He's like creating a burn book through executive orders. Back to those lawsuits, though, in the immigration space. All the props in the world to Rekha Sharma Crawford, Brian Green, Jennifer Coberly, and Jesse Bless for filing a lawsuit on behalf of Ayla and Banaka Kolpi LLP in response to U.S.CIS's outrageous publication of new, very slightly amended forms last week without any notice or any grace period for use of the old forms. That, of course, completely screwed thousands of non-citizens and their attorneys for no reason at all. It must have taken those attorneys a lot to get that lawsuit filed so fast, on top of all their other work. Well done, guys, and thank you very much to Ayla for having the back of the immigration bar. Speaking of back, and not a baby with back, but more of a return, shall we say. The Second Circuit is back with a vengeance. The Second Circuit accounts for 3 of the 5 cases this week, with 2 being quite barn burners, so much so that I had to splice them up throughout the episode. So enjoy, I beg you, in this, the second episode of March. First up is Lau v. Bondi, published by the Second Circuit on March 4th, 2025. This case is about crimes involving moral turpitude and applicants for admission. Mr. Lau was from China and became a lawful permanent resident in 2007. Just under 5 years later, he was charged with third-degree trademark counterfeiting in violation of New Jersey law. Because of this, when he departed the United States and re-entered later that year, DHS didn't treat him like a green card holder, but did parole him in for deferred inspection pursuant to INA Section 212 D5. Remember, he only had a charge at the time, but Mr. Lau pled guilty a year later. Trademark counterfeiting in violation of New Jersey Revised Statute, Section 2C:21-32C. 2 years probation. Because of all of it, DHS initiated removal proceedings, charging Mr. Lau not as removable as a lawful permanent resident, but as an arriving alien applicant for admission who was inadmissible because of a CIMT conviction. If it's a CIMT conviction, DHS is allowed to do this. That's INA Section 111813C. It permits DHS to treat LPRs returning from, say, a one-day vacation abroad much worse than LPRs who never left the United States for the exact same conviction. Query why? Not only did Mr. Lau argue that the conviction was not a CIMT, he asserted that if it was, it met the petty offense exception and therefore shouldn't permit DHS to treat him as an arriving alien. DHS's burden to establish that he is to be treated as an arriving alien, by the way. In the alternative, he applied for a Section 212H waiver of his inadmissibility. But among other things, that waiver requires that the non-citizen have, quote, lawfully resided continuously in the U.S. for a period of not less than 7 years immediately preceding the date of initiation of proceedings to remove the non-citizen, end quote. Now, Mr. Lau admitted that he had only been an LPR for 6 years, but he argued that his time in the U.S. in non-immigrant status before that, which was getting pretty frequent before he became an LPR, should count and get him to the 7 years. A Section 212H waiver also requires an extreme hardship shown to a qualifying relative, by the way. An immigration judge deemed Mr. Lau an arriving alien, denied the waiver, ordered him removed, and the BIA affirmed. Mr. Lau lost his green card because he traveled. But the Second Circuit did not agree. And to me, it's not entirely clear what was argued at every stage of this case, but here, before the court, the Second Circuit had issue with treating Mr. Lau as an arriving alien rather than as a returning LPR. And it's not because the Second Circuit doesn't believe the conviction a CIMT. No. The Second Circuit held that, quote, a pending criminal charge does not provide the clear and convincing evidence of a CIMT necessary for DHS to consider an LPR an applicant for admission at the time of reentry and then parole him, end quote. And that seems like a bit of a big deal in these scary times, to me at least. When and how an LPR can be treated as an arriving alien applicant for admission is about as old as the INA. The Flutie Doctrine, and all that stuff, but now it's all governed by INA Section 11813C. And that section makes quite clear that LPRs returning to the United States from abroad, quote, shall not be regarded as seeking an admission into the United States, end quote. Unless, of course, DHS establishes that an exception applies. And one of those exceptions applies if the non-citizen, quote, has committed, end quote, a CIMT. That's INA Section 11813C, V. Now, true. Under Second Circuit precedent, at least, the legal consequences of Section 11813CV attach from the time that the non-citizen commits the offense, not when he's convicted. So that's pretty bad for Mr. Lau. But even in that decision, Centurion v. Sessions, the Second Circuit recognized that, quote, in practice, those consequences may not be enforceable in any meaningful way until after the LPR is convicted of the crime, end quote. Because how can DHS meet its clear and convincing evidentiary burden to prove that someone is properly treated as an applicant for admission for committing a CIMT unless they, 1, admit it when they're trying to come in, or 2, are convicted? DHS, of course, knew this with Mr. Lau. That's why they paroled him in, right? Waited for the criminal case to shake out and then NTA'd him. Sure in their ability to then prove that he had committed a CIMT that permitted them to treat him as an applicant for admission. Too cute by half, reasoned the Second Circuit. So yeah, watch what you say at the border, returning LPRs. It's not too cute for the BIA. The BIA flat out said that DHS can do this in matter of Valenzuela-Felix in 2012. Quote, in essence, the BIA concluded that DHS officials had the authority to parole LPRs into the country at the time of re-entry, only to later reclassify their entry, nunc pro tunc, based on the subsequent results of the criminal prosecution, end quote. And with that holding, the Second Circuit, quote, cannot agree, end quote. The court explains that the INA, quote, explicitly provides that an LPR shall not be regarded as seeking an admission into the United States, except in certain enumerated circumstances, end quote. Great argument, counsel. The INA doesn't say anything about paroling in LPRs suspected of committing a crime, but it's quite clear about when and not when they must be treated as LPRs. Quote, critically, the INA does not provide that an LPR may be treated as seeking an admission when he has been charged with a crime or is believed to have committed a crime. It permits such treatment only when an LPR has committed a crime, end quote. Straight up statutory interpretation. And with DHS bearing the burden of proof, well, the Second Circuit doesn't understand how a simple charging document can meet it. Big problem for DHS because additionally, quote, the INA is also explicit that the parole process is authorized only for non-citizens applying for admission to the United States, end quote. So DHS can't parole in an LPR unless the LPR is an applicant for admission. But DHS can't establish grounds for treating a returning LPR as an applicant for admission based simply on a charging document. Suspicion doesn't cut it, states the Second Circuit quite explicitly. Quote, the parole procedure sanctioned by Valenzuela-Felix is therefore contrary to the INA's text, end quote. Big deal. Matter of Valenzuela-Felix is bad law in the Second Circuit, which creates a circuit split with the Fifth and Ninth Circuit, although the Ninth Circuit's case at least was based on Chevron deference. Contrary to the plain text of the statute, explains the Second Circuit, quote, DHS must determine whether an LPR is an applicant for admission as a threshold matter before it is authorized to parole rather than admit that individual, end quote. Emphasis by the court. Because after all, explains the Second Circuit, there's an entire framework to remove LPRs, treating them as LPRs. That's INA Section 237. DHS can't get around the 237 protections simply because the LPR was charged with a crime without conviction and then left the United States briefly. I remain curious whether this trademark thing is a CIMT. Left for another day, I guess, if DHS can and decides to bring a Section 237 charge. Because Mr. Lau won, and will have his removal proceedings terminated. Therefore, big congratulations Mike P. Gao for petitioner. A word of caution. All of this is uber important. Because if this Trump administration is anything like the last one, they will very much try to treat as many returning LPRs as applicants for admission as possible, given that they can detain such people, and such people are a bit of low-hanging fruit. But not in the Second Circuit, based on a charge without conviction alone. Did I mention how important it is not to admit criminal conduct in your secondary interviews returning LPRs? Given treating LPRs as applicants for admission, the new NTA policy, and all the other uncertainty going on at present, we immigration attorneys all need to be advising our LPR clients what risks they have by traveling abroad or when they apply to naturalize. And if you've got a client like Mr. Lau, well, maybe advise that they re-enter through JFK. And that is Lau v. Bondi. Our Second Circuit case is Penaranda v. Bondi, published by the Second on March 7th, 2025. This case is about deficient notices to appear and false testimony. Mr. Penaranda is from Ecuador and has lived in the United States without authorization for over 2 decades. Indeed, he's been here pretty much his entire adult life. When placed in removal proceedings, he applied for non-LPR cancellation of removal, given the extended amount of time he'd been in the United States, asserting that his U.S. citizen wife and lawful permanent resident parents would suffer exceptional and extremely unusual hardship if he was removed. But that wife was not his first wife. Back in 2007, he was actually placed in removal proceedings for the first time, while he was dating a woman named Lucia. But Lucia was not yet divorced from her husband. And so, In a very unfortunate decision, Mr. Penaranda married Lucia's daughter, Lucy, a U.S. citizen, in an effort to stave off removal and get lawful permanent resident status. And Lucy did indeed file an I-130 petition for Mr. Penaranda. He then filed a Form I-485 adjustment of status application in immigration court, and the court terminated proceedings to allow USCIS an opportunity to adjudicate the whole thing. USCIS approved the I-130, but somehow not the I-485. That remained pending until, in 2010, Lucy called an ICE tip line and confessed to fraud. She then signed a sworn affidavit with FDNS and everything, saying it was all her mother's idea. No bueno. USCIS revoked the I-130 approval, denied the adjustment of status application, and placed Mr. Penaranda back in removal proceedings. Where? He applied for non-LPR cancellation, because again, by this time he had the 10 years. During proceedings, Mr. Penaranda divorced Lucy and married her mother, Lucia, who was by this time a naturalized U.S. citizen. And that's totally a real marriage. And now, Lucia filed an I-130 petition with USCIS to try to get Mr. Penaranda to adjust status through her. The new removal proceedings were continued multiple times for the new I-130 to be decided. And Lucia and Mr. Penaranda even submitted an unsworn letter from Lucy recanting the fraud. So I don't know what to say. But USCIS made an INA Section 204C fraud finding anyway, which means it couldn't grant Lucia's I-130 petition. So non-LPR cancellation of removal in immigration court, it is. Which an immigration judge denied based on a finding that all of this meant that Mr. Penaranda did not have good moral character during the 10 years immediately preceding his application, as non-LPR cancellation requires. The BIA affirmed, and the Second Circuit says a lot of things about that application in this very long decision. But the good moral character stuff is really what it came down to. At first I wasn't going to get into it, but okay, fine, I'll get into the chismes. I must admit that DHS submitted a whole heck of a lot of evidence to show that the Lucy thing, the marriage to the daughter, was a fraudulent marriage, including but not limited to the FDNS affidavit, where Lucy even blames another New York immigration attorney for lots of this. Really bad look all around. Mr. Penaranda, for his part, remained steadfast on the stand as to the marriage's validity, blaming the divorce from Lucy in part on her, quote, drug use, infidelity, and failure to take care of her children, end quote. Lucia, Lucy's mother, seems to have corroborated this with her testimony, and then came Lucy to testify. She denied the fraud, but to the Second Circuit provided contradictory testimony. To the IJ and the BIA too. As I mentioned, the IJ didn't believe him. And well, not testifying truthfully in immigration court, if that's what happened here, is almost always going to make you lose. Which again is what happened. As I mentioned, good moral character. INA Section 101F6, to be exact, makes a non-citizen statutorily lack a good moral character if they have, quote, given false testimony for the purpose of obtaining an immigration benefit, end quote. During the relevant time period, of course. After the BIA affirmed, Mr. Penaranda, in 2023, filed a motion to terminate or remand with the BIA, arguing that actually the removal order was invalid, because the notice to appear that initiated proceedings way back when lacked the date, time, or location of the first hearing. The BIA denied that motion, and now it's all before the Second Circuit, which ruled against Mr. Penaranda. Starting with the NTA stuff, the Second Circuit reaffirmed that deficient NTAs do not implicate jurisdictional concerns, but are instead a claims processing rule violation argument, and that objections to an NTA must be made timely or they're waived, and that doing so in a motion to remand before the BIA for the first time is not timely. Before coming to that ruling, though, the court had to tangle with a Loper Bright argument, as Mr. Penaranda argued that the Second Circuit owed matter of Fernandes no deference. Matter of Fernandes being the BIA's seminal decision about how to make claims processing rule deficient NTA arguments. And that's true, the Second Circuit does owe matter of Fernandes no deference. But the Second Circuit has already independently held most of what matter of Fernandes held about deficient NTAs, and for the rest, well, this panel agreed. Nor did the Second Circuit believe that Mr. Penaranda needed to wait until matter of Fernandes to know that he had to assert a deficient NTA argument before the immigration court. INA Section 239A, the statute that governs NTAs, quote, has been on the books since 1997. And all Mr. Penaranda had to do to raise this argument was to compare his notice to appear to the statute itself. Somebody has to be the first one to raise a legal argument, and it could just as easily have been Mr. Penaranda, end quote. Importantly to me at least, explains the Second Circuit, this is not a situation where the BIA held otherwise in prior decisions and then, quote, flip-flopped, end quote, or, quote, sandbagged, end quote, Mr. Penaranda. Plus, to the Second Circuit, matter of Fernandes wasn't really the first of these decisions, as we all know from the podcast. Lots of arguments about deficient NTAs have been made over the years. Moving on then to the denial of cancellation of removal. The Second Circuit held that post-Wilkinson from the Supreme Court, the INA Section 101F6 false testimony finding can be a sufficient mixed question of law and fact that can be reviewed even in the cancellation of removal context. But only sometimes. Only if what's being brought is actually a mixed question of law and fact. Simply asserting issues of fact, like the reasons Mr. Penaranda's testimony wasn't great, but not intentionally fraudulent, are too factual to the Second Circuit. As such, explained the court, Patel and INA Section 242A2B preclude the court from reviewing the argument. And really, that was the gravamon of what Mr. Penaranda was arguing on petition for review. That is, that his testimony should not be deemed fraudulent, and that there were other reasons for the discrepancies asserted. And heck, the Supreme Court kind of said as much about INA Section 101F6 in Cungus v. United States, explains the Second Circuit, that it's really a factual inquiry. Similarly, challenging how the IJ weighed evidence in reaching the finding is unreviewable. Rough stuff. Unless, though, as the Second Circuit mentions in a footnote, and as is the argument in pretty much all circuits, the non-citizen argues before the circuit that the IJ totally overlooked or ignored or mischaracterized evidence. Just saying. That leaves the colorable claim that the Second Circuit could review on this issue, that is, that the IJ held Mr. Penaranda to a higher standard in proving that his marriage to Lucy wasn't entered into for immigration purposes. See, Mr. Penaranda argued that the IJ had held that because Mr. Penaranda married Lucy while he was in those first removal proceedings, that Mr. Penaranda had the burden to show by, quote, clear and convincing evidence, end quote, that it was a valid marriage. That is the standard for U.S.CIS to apply when a non-citizen is married and files an I-130 while in removal proceedings. But is that the standard for an immigration judge to apply too? Unclear. And unaddressed here because the Second Circuit held that that's not actually what the IJ did. Rather, the court believes that Mr. Penaranda's argument misreads the immigration court transcript. Which means it's a loss for Mr. Penaranda. Lots of arguments made in this one, if you didn't catch it. And before we leave the case. Not for nothing. In a footnote, the Second Circuit relays that while Mr. Penaranda was totally inadmissible for being in the country without inspection or admission, an immigration judge did not sustain DHS's second inadmissibility allegation under INA Section 212A6CI. Fraud or willful misrepresentation. The reason? It was Lucy who filed the I-130 petition with the fraud, not Mr. Penaranda. Interesting stuff. And remember the argument, if it can ever help you or your client. Probably your client, right? And that is Penaranda v. Bondi. Let us turn to some crimmigration before we take a break, with Mohammed v. Bondi, published by the Sixth Circuit on March 4th, 2025. This case is about aggravated felony arson offenses. If arson in violation of Virginia Code Section 18.2-77 is one, Miss Mohammed is removable and ineligible for any of the relief she applied for. Not good for her, given her longtime status as a lawful permanent resident from Trinidad and Tobago. It is, said an immigration judge in the BIA. And so did the Sixth Circuit. It's a lesser discussed aggravated felony, INA section 101A43EI, quote, an offense described in, end quote, 18 U.S.C. section 844I. That federal criminal statute, in turn, is the federal arson statute. And under that statute, it is criminal to, quote, maliciously damage or destroy or attempt to damage or destroy by means of fire or an explosive any building, vehicle, or other real or personal property used in interstate commerce or in any activity affecting interstate commerce, end quote. The categorical approach applies, so that federal definition is quite important. Does Virginia cover more conduct in its arson statute? If it does, then you don't have a categorical match, and the Virginia offense isn't an aggravated felony. But the Sixth Circuit said no, it is a categorical match. Aggravated felony finding and removal order affirmed. It all comes down to the minimum conduct criminalized in Virginia. That's the focus, no matter what Ms. Mohammed did, but even it is covered by the federal arson statute. The Virginia statute is a long block quote statute. But the Sixth Circuit summarizes it as follows, quote, a person violates the Virginia arson statute if she 1. Maliciously, 2. Burns or aids and abets the burning of, 3. A dwelling house, certain occupied property, or certain property that people, generally, occupy, end quote. The term malice was used there, and in Virginia, that term means, quote, the doing of a wrongful act intentionally, or without just cause or excuse, or as a result of ill will, end quote. So says the Sixth Circuit, quote, the minimum conduct criminalized under the Virginia arson statute involves intentionally or without just cause, aiding and abetting the burning of property identified in the statute, end quote. The court saw a match to the federal arson definition above, particularly as the categorical approach ignores that interstate commerce element, which is required to convict federally. I must admit, begrudgingly, that ignoring the interstate commerce federalism element does make sense, and in any event that's Torres v. Lynch from the Supreme Court in 2016. So the only real difference is that Virginia expressly criminalizes the aiding and abetting of arson, while the federal arson statute does not, and that's what Ms. Mohammed attacked. But explained the Sixth Circuit, quoting the Supreme Court, that just makes Virginia like all states. All states, it seems, have removed the distinction between principals and accomplices to crimes, and convict aiders and abettors like principals. Similarly to the Sixth Circuit, the federal aiding and abetting statute, 18 U.S.C. Section 2, has done the same thing. It abolished the common law distinction between principals and accessories. So much so to the court that aiding and abetting indictments, apparently, don't even include a reference to Section 2. Federal prosecutors just charge the principal offense, even for aiding and abetting. As such, the Sixth Circuit, quote, the federal arson statute's silence about accomplice liability and the INA's failure to expressly reference Section 2 represents nothing more than a technical consideration that has no place in our application of the categorical approach, end quote. Compelling categorical approach arguments, though, I admit. But of course I would, right? Apparently, the Sixth Circuit's holding here that the categorical approach doesn't care about the state's express criminalization of accomplices as principals as compared to the federal government's general silence. Apparently, that holding is shared by the 9th, 4th, and 11th Circuits. Although the 9th Circuit was kind of all over the place there for a minute until they went in Bonk and Alfred, episode 153, if you remember that very complicated series of cases. Aiding and abetting does not describe separate elements of a crime, explains the Sixth Circuit. So the state's criminalization of accessories as principals, similar to what the federal government does no less, has no impact on the categorical approach analysis. Meaning, Ms. Mohammed lost her case because she has an aggravated felony conviction. And that is Mohammed v. Bondi. Elevate your advocacy and storytelling skills at the annual Immigration Court Trial College in Kansas City. Get ready for a transformative experience at the annual Immigration Court Trial Advocacy College, now hosted by the Pen and Sword, formerly the clinic at Sharma Crawford Attorneys at Law. That's friends of the pod and friends of the Kevin, Rekha and Michael Sharma Crawford, excellent immigration attorneys. The college convenes from April 24th to 26th and will focus on detentions, bonds, and release for 3 action-packed days of hands-on practical training and expert insights. This is not your average Talking Heads program. This is real cases, real witnesses, and real courtrooms designed to give you a real edge in your immigration practice. Put another way, this isn't just another training. It's an opportunity to transform your practice and fight for justice in a way that matters. Sharpen your skills, amplify your voice, defend immigrant rights like never before. Don't miss out, because space is limited. Check out all of the links to Rekha and Michael Sharma Crawford, their firm, and the Pen and Sword in the show notes. And if you want to get a bit of a discount for the Trial Advocacy College, click on the link in the show notes or use promo code IMREVIEW2025. That's IMMREVIEW2025. Keep up and join the good fight. Are you fighting like a maniac? Completely overwhelmed by the chaos of the new administration? Immigration policies are shifting fast, the pressure is piling up, and clients are desperate for help. You're working around the clock, but there's only one of you. Well, Staffy's got your back. Staffy's bilingual virtual paralegals and administrative assistants handle USCIS forms, client intake, evidence gathering, and scheduling, so you're not drowning in paperwork while trying to fight for your clients at the same time. Stop running on empty. Staffy gets you a trained, ready-to-go team fast with HR-backed support, onboarding, and continuous training. You don't have time to do it all alone, and you don't have to. Schedule a consultation at staffy.cc, that's stafi.cc, and claim $500 off your first month. I'm back! With Laguna Rivera v. U.S. Attorney General, published by the 11th Circuit on March 5th, 2025. This case is about asylum and credibility. The 11th Circuit doesn't start off with lots of facts, but does make clear that Mr. Laguna Rivera, who is from Nicaragua, filed his asylum application over a year after entering the United States. That makes it time-barred, unless it's subject to an exception which the IJ and the BIA held it wasn't. Therefore, said the 11th Circuit, it can't even review that finding. There are somewhat competing statutes on this issue, that is, circuit review of the timeliness of an asylum application. But in 2005, the 11th Circuit held that the timeliness of an asylum application filing is too discretionary a decision and not a constitutional or question of law over which it, the 11th Circuit, has authority to review. Now true, the 11th Circuit explains here, Supreme Court immigration jurisdiction case law has changed a lot since 2005. But last year in APA v. U.S. Attorney General, an 11th Circuit panel held that the 11th Circuit still lacks jurisdiction because the timeliness of an asylum application is not a mixed question of law and fact. At core, it's just a discretionary factual determination. APA v. U.S. Attorney General binds, and even tangled with the relevant Supreme Court decisions that Mr. Laguna Rivera argued governed here. No jurisdiction in the 11th Circuit to review an IJ and the BIA's determination that an asylum application is or is not timely. Even when the argument is based on changed country conditions, though? That's just me, but I would think that that's not discretionary. That's literally or nearly literally identical to the analysis done on changed country condition motions to reopen, which the circuits do have jurisdiction to review. I wonder if that APA decision is about changed country condition motions to reopen, because I don't think this case here is. More research warranted if your asylum timeliness argument pertains to changed circumstances in the country from which your client is applying for asylum. But this is all definitely not good for non-citizens in the 11th Circuit.
Without the asylum application, that left only withholding of removal and Convention Against Torture protection, but an IJ and the BIA denied that based in large part on an adverse credibility finding. Before getting to the meat of it, the 11th Circuit does explain some legal standards that are worth mentioning, as I often skip over them. But this decision actually has quite a bit of law spliced in. For example, for asylum and withholding of removal, without a past persecution showing, an applicant must provide, quote, specific, detailed facts, showing that he has a good reason to fear that he will be singled out for persecution, end quote. Or in the alternative by proving, quote, a pattern or practice of persecuting a group of persons similarly situated to himself, end quote. As to that latter thing, quote, to prove the existence of a pattern or practice of persecution, he must prove that the mistreatment of persons similarly situated is extreme and pervasive, end quote. So there you go, some standards. In this case, it appears that Mr. Laguna Rivera was explaining that his relatives experienced very bad harm in the 1990s, but the agency didn't really see a connection to Mr. Laguna Rivera. As to his current fears, the immigration judge believed that Mr. Laguna Rivera had, quote, embellished key aspects of his story and that his claim is not believable based on inconsistencies and omissions identified in the record, end quote. The 11th Circuit didn't see a problem with any of this. True and not for nothing, quote, an applicant can support his fear of persecution by reference to the persecution of his family, end quote. Remember that. But to do so, he also, quote, must explain convincingly why he would receive the same treatment, end quote. Not done here sufficiently, believed the court, particularly as the harms to the family, quote, happened a long time ago, end quote, and certain family members lived in Nicaragua for a long time after the harms. Now, Mr. Laguna Rivera also relayed that his brother was beaten by Nicaraguan paramilitaries recently in 2018. But the IJ didn't find that believable for a few reasons, and the 11th Circuit didn't believe that the arguments against that compelled reversal. That Mr. Laguna Rivera was a bit politically active in the late 1990s is just too far in the past and disconnected from any specific fears to this day for the 11th Circuit to overturn the BIA. Handing out flyers, distributing food, and doing tasks for a group without any formal political position? Quote, this is not the kind of political involvement we've indicated before would likely lead to a government keeping track of someone for decades after they were politically involved, end quote. To the extent Mr. Laguna Rivera was worried about what the Nicaraguan government is doing to people who return to that country now, based on rumors that are circulating in the community in America, rumors that I too have heard from clients, Mr. Laguna Rivera has no proof, said the 11th Circuit, so the court believed the agency justifying in rejecting this fear. True, an immigration judge must consider supporting affidavits, even if the IJ finds the non-citizen not credible. So remember that. But the IJ did that here, said the 11th Circuit, and found them lacking. Other arguments were deemed unexhausted by the 11th Circuit, and so the court affirmed the agency and the removal order. And that is Laguna Rivera, the U.S. Attorney General. Meaning we return to the Second Circuit to conclude the show with Tian v. Bondi, published by the Second Circuit on March 5th, 2025. This case is about asylum. Mr. Tian is from China, entered on a business visa, overstayed, and applied for asylum. As the basis, he asserted that he had been, quote, persecuted by the Chinese government because of his opposition to that government's forcible demolition policy by which villagers' homes are demolished without just compensation, end quote. In removal proceedings, an immigration judge deemed Mr. Tian credible, and so the Second Circuit believed his story. Essentially, the Chinese government decided to demolish all the homes in his village, offering only 50% of their value to many residents, including Mr. Tian. Mr. Tian refused, but all the homes in the village are kind of connected, meaning that demolishing the homes of those who accept the money is pretty much the same as demolishing everyone's home, including Mr. Tian's. Mr. Tian and others protested, barricading a road to prevent the demolitions. Mr. Tian provided photos of the demonstration to the immigration court, along with photos of the protesting banners. Police dispersed the protesters with violence and arrested Mr. Tian and 12 others. Mr. Tian was only released after signing a document promising not to protest in the future. After this, the government offered him 70% of the value of his home. So, protests are not fruitless. Apparently he signed that under duress, as the government officials said that his family would be, quote, broken, and that people may die, end quote, if he refused. Then they demolished his home, and they never paid him. Quote, further, while Mr. Tian built a shelter out of wood to house him and his family, the government eventually cut off the supply of utilities to the shelter, end quote. Having not been paid, even 3 years later, Mr. Tian went to the local office to inquire, where he was handcuffed by police and interrogated about why he was making trouble. Then they beat him pretty bad, and he presented medical records in court to prove it. He was warned of worse things if he continued to inquire and protest. Mr. Tian's family was ultimately resettled in new housing, but 7 years after all these events occurred. No mention either of whether Mr. Tian was ever paid. An immigration judge didn't believe that this was all bad enough to be past persecution, or that it was happening because of Mr. Tian's political opinion. The IJ believed that because Mr. Tian had illegally blocked the road with the other protesters, for example, that this was permissible legal prosecution. Other findings were made too, and the BIA affirmed, quote, in a 2-page opinion, end quote. The Second Circuit disagreed with the agency, although they seem a bit pained, if you ask me. Quote, while the severity of Mr. Tian's claims pale in comparison with many asylum requests, we are constrained to conclude that the agency's analysis of his claims was legally deficient, end quote. Whatever you gotta do to get there, Second Circuit. Whatever you gotta do. On nexus, we're talking political opinion or imputed political opinion, one of the 5 listed protected grounds. And in all circuits, that doesn't necessarily mean straight-up political party type stuff. In the Second Circuit, for example, quote, the important questions for determining the nature of the applicant's opposition are whether the applicant's actions were directed towards a governing institution or only against individuals whose corruption was aberrational, and whether the persecutor was attempting to suppress a challenge to the governing institution, end quote. This is a factual, complex inquiry, explains the court. To the Second Circuit, quote, the political opinion that Mr. Tian repeatedly and openly expressed to the government officials was the same basic principle enshrined in our Fifth Amendment. Nor shall private property be taken for public use without just compensation, end quote. The IJ didn't believe that's actually the reason that all this happened to Mr. Tian, but explained the Second Circuit, even assuming arguendo that some or all of his arrests were legitimate under Chinese law, that's only half the inquiry. One central reason for the beatings, threats, and arrests could have also been his perceived anti-property confiscation political opinion. Mr. Tian's, quote, vigorous expression, end quote, at that, states the Second Circuit. Diving deeper into Nexus, for example, he was only released that first time after swearing to no longer protest, and his agreement to permit the demolition was made after the Chinese government threatened to break his family. Not to mention that the final assault and arrest only occurred following, quote, his assertion of his right to the promised compensation and his railing against the government's alleged corruption in carrying out the demolition policy, end quote. Seems like his political opinion, or imputed political opinion, was indeed one central reason for what happened to him. The IJ and BIA having, quote, effectively ignored this possibility, end quote, cannot stand to the court. Plus, he corroborated his story, the Second Circuit explains, both with direct evidence and country condition reports. As to the latter, quote, there is no indication that the agency considered any of this evidence at all, end quote. Can't do that. To be clear, prosecution can be persecution, and the IJ and the BIA, quote, failed to consider several facts indicating that the arrests may have been pretextual, end quote. Here, it sure seemed like it might have been, particularly as the police, quote, educated, end quote, Mr. Tian at the police station that first time. Educated him not to protest, that is. And the record doesn't say anything about actual formal criminal charges anyway. The IJ and the BIA must consider whether criminal arrests and presumably prosecutions are pretextual, or I suppose, whether one central reason is a pretextual, protected ground. Say that 5 times fast. Nor does it matter to the court that Mr. Tien was offered partial compensation. A political opinion is a political opinion. So it's a remand on that. But there's more. The Second Circuit isn't thrilled about the agency's Convention Against Torture analysis either. Despite the pretty severe beatings described, quote, in a conclusion, devoid of any reasoning, the BIA then affirmed that Mr. Tien did not experience mistreatment rising to the level of torture, end quote, and added that he, quote, cannot met, his burden of proof based on a string of suppositions that he will be targeted for torture and that authorities would acquiesce or turn a blind eye to such harm, end quote. The Second Circuit says that is all insufficient for review. And what does that even mean when it was the police who beat him? I'm confused too, Second Circuit. In any event, quote, failure to consider material evidence of the record is ground for remand, end quote. And a remand there was. Remember this one, folks, as an increasing amount of authoritarian and would-be authoritarian regimes appear to be weaponizing their criminal justice systems to go after people they don't like under the guise of legality. And all of it, of course, means congratulations, Troy Nader Moslemi, for petitioner. And that is Tien v. Bondi.
So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzelli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. And we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.